This part of the conference is listed on your program as a keynote, but we decided we'd just go a little bit in a different way and hold it as a conversation. We're really, really delighted to have with us as our keynote conversationalist, Elton Anglada. He comes from the Philadelphia Defenders Association, which is, some of you may know, some of the most progressive work is being done right now in the Philadelphia court system. Elton is a senior trial attorney in the Juvenile unit of the Philadelphia Defenders Association. We've had the head of the Defenders Association here at various different conferences, Keir Bradford, and they really have a lot to say and a lot to tell us, a lot to tell the rest of the country about what they're doing. Elton's full bio is in the program, so I won't repeat it, but I'll turn the mic over to Joe, who's going to engage Elton in conversation. And don't worry about eating. It may be impolite in some circles, but for us, eat, listen, enjoy.
So hi, everybody. This is not necessarily anything you'll have to take notes on, so you can just go ahead and eat and relax, and hopefully this will be like a good radio conversation. I asked Elton to come here today because he has, not because of his kind of sterling career in juvenile justice, but because he has such a unique insight into a lot of things that are on the periphery of juvenile justice. And you'll see what I'm talking about when we get to some of the topics. So he's been listening this morning, and so the first thing I'm going to ask him to do is talk about, this is particularly relevant because of the last panel, to talk about data, policy, and the actual implications of how the data and the policy are implemented. And I mean, I thought the discussion about parole officers was pretty astounding in terms of their ill-preparedness to be part of a system that's more and more relying on the what we're learning from science and behavioral science. So, you want to start with that, please?
Thanks, Joe. First of all, I'd like to thank you, Joe, for inviting me here to John Jay. I was here a few years ago. I love this school. I love the facility, and I love the work that you all are doing here. When you say I have a unique perspective, that's a kind way of putting it. Often what I find is that my opinions seem to annoy people both on the right and the left. And I'm not always sure why. I often feel like I'm very alone in my positions, and that's probably going to be the case today during lunch also. I wanted to just tell you a couple things about me because it informs my opinions. I've been a public defender for 25 years, my entire career, most of it defending juveniles. I am primarily a trial lawyer, but I also have spent the last decade working as the chief of the juvenile unit at the Philadelphia Defender Association, and also working with JDAP, which is the Juvenile Defender Association of Pennsylvania. We have another board member here who will be on the next panel for JDAP, and JDAP is a state version, a small, modest state version of the NJDC. In other words, a statewide organization of juvenile defenders whose goal it is to improve juvenile justice for juveniles. And in that capacity, I've had the opportunity to do a lot of policy work, both statewide and regionally in the Northeast. But my main focus is as a trial lawyer. And the question that Joe asked me as I was listening to the speakers this morning, and I know Marshall Levick for years, and Kim Dvorak, and the data is true. When Marcia says, if we stop collecting data, then we just don't address the issue. When she's talking about how OJJDP just announced that they're no longer going to collect data on disproportionate minority contact, that is horrific. That's code for them saying, we don't care about that anymore. That's what that means. We don't care about disproportionate minority contact. Where they can say all they want about, well, we're diverting this to public safety, that's just polite way of saying we don't give a crap anymore about disproportionate minority contact, which is horrific, right? So when Joe originally reached out to me and said, talk about juvenile justice reform in the Trump administration, and that's the kind of thing I'm thinking about. I turned to my office mate and I said, that's an oxymoron, right? Juvenile justice reform in the Trump administration. What does this look like? It doesn't. The landscape is bleak. There were some comments earlier at earlier sessions about funding being cut, both on the state and national level. NJDC and other organizations are having their budgets cut. But one thing that I wanted to focus on, because you all are reporters and journalists, and I'm an attorney, and we both share something in common in that we barter in language, right? What our lives are about, yours in a slightly different way, and mine is the rhetoric, the art of rhetoric, about the precise use of language. And where I so often see all the data going wrong is where it goes in the weeds is in the misuse of language or different people using the same word to mean different things, so that you get lost. Results don't happen. I can't tell you how many times I go into courtrooms or go into jails or go into probation offices, and I don't see the results that we're supposed to be seeing. I'll give you a couple of examples. There was a discussion at the last panel about trauma-informed care, right? That's a whole body of science. I've had Sandy Bloom come speak to juvenile defenders all across Pennsylvania about the science of trauma-informed care. Her organization certifies service providers as being trained in trauma-informed care. And yet when I go to those juvenile jails, when I go to Glen Mills, when I go to St. Gabe's, when I go to YDC Louisville, when I walk in the doors, I ask myself, where's the trauma-informed care? I don't see it. It's not happening here. What's going on? And they say, well, we're certified. We got trained. We're certified in trauma-informed care. So, the data is great. The theories are fantastic. But what often happens is that in real life, it doesn't happen. And why isn't it happening in trauma-informed care? Well, in part, it's a fiscal problem, which is that turnover at these facilities is huge. So because they have to pay their employees very little so that they can compete and get the bids. That means that even if you train their entire staff, within 6 or 9 months, no one who's there was even trained in trauma-informed care because the turnover is so high. And more importantly, when I talk to the staff about trauma-informed care, they would say to me things like, well, we do trauma-informed care. But to them, you know what trauma-informed care means to them, to the service providers? It means making sure that their workers aren't traumatized working with our clients. I'm not kidding you, right? That's what because a small part of trauma-informed care actually deals with the trauma that we as service providers and we as lawyers, because it is traumatic to bang your head against the wall every day representing juveniles who have committed horrible things or are getting railroaded by the system and dealing with disproportionate minority contact. It is traumatic, and it can be traumatic for workers. But that's not really what the main thrust of trauma-informed care is about, right? The main thrust of trauma-informed care is to make sure that the kids aren't further traumatized by the system that we put them in, because they come into the system already deeply damaged. And yet, when I talked to workers, what I saw was a focus on, oh yeah, we're making sure that our workers aren't traumatized working with these kids. And I think about you guys as journalists and reporters, because this is just, it's semantics, right? They're playing with the language. Yeah, we're doing trauma-informed care, except that the same words mean something different to them.
Elton, isn't it all about the problem throughout the criminal justice system is about culture and changing culture and having the time to do that and recognize that it often takes 8 or 10 years if you have a really good leader to make that happen?
Yes. Change moves with glacial haste in this business, right? It happens very slowly. Steps are incremental. But having said that, there are definite signs on the horizon that, as someone mentioned earlier today, that the pendulum is shifting the other way with regard to juvenile justice, with regard to incarceration of juveniles, with regard to trying juveniles. Yes, arrests are down, but that doesn't mean that the way the juveniles who are arrested, that are currently being arrested, are being treated better. And in fact, now that I'll mention it again, where I feel like we get lost is in what the words mean. So that rather than, like for example, today there was a discussion about a couple of very good questions about school resource officers. SROs, they're called. That's a term, by the way, that I forbid my staff from even using in court. You're not allowed to say school resource officers at the Philadelphia Public Defender. They're not school resource officers. What is the resource? Getting arrested? How is that a resource? They're school police officers. Who came up with that term? That term was created by people who wanted to apply a lesser standard of proof to those police officers. That rather than needing probable cause, let's say they need only reasonable suspicion. So let's call them something better. It's semantics. And so I will not buy into the argument that they are school resource officers. When I go in court and I make a motion to suppress, or my lawyers argue for motions to suppress, we're talking about school police officers. I don't consider arresting juveniles a resource. I don't think that they are a resource to the school. Mike pointed out that in schools that have school resource officers, arrests are up. And duh, who didn't see that coming, right? I mean, if there's police around, more kids are going to be arrested. And that is why we have to pay attention to the language. And I think often we lose the fight, we lose the battle, we get caught up in adopting their language. No, let's not call them school resource officers. They're not that. They're school police officers. You want to apply a probable cause standard to them? Then let's call them what they are. They're cops.
So this is just an obvious question, but what do you suggest journalists do when they're looking at these kinds of terms and what they're supposed to do? Just take a harder look and say what's going on here?
Well, look, I don't buy into the theory that some put forward that journalists or the media control the news, and I don't believe that. I think that the journalists and reporters report that news which is important and what people want to hear, right? I mean, I don't believe that that in this whole kind of notion that CNN or the liberal media is somehow controlling the news. I don't subscribe to that. And Frank, I think it's all poppycock. But I think it's also important, though, that we be very careful about the language we use. You have to be very careful because you can get indoctrinated or use their language without even knowing it. For example, the discussion about, as I mentioned before, about school resource officers. You have to be very careful. Just when you adopt their terms. In law school, the first thing that they teach us is one of the things is how to do an appellate brief, and that what they teach us to do is it's two sides, right? It's the appellant and the appellee, and they both have to make a statement of the issue, and both sides will state the issue completely differently. It's for you guys, it's the headline, right? What is the headline of your story? What is the story? The headline is so crucial, and for defense counsel or for prosecution, for lawyers, how you state the issue is crucial. So we share that in common, but we have to be more careful or we are going to lose. Right now, I feel like the Trump administration and like the right is setting the agenda, they're setting the tone, and we're responding to them. I mean, we're going to talk, I think, in a minute about the current nominee for the Supreme Court, and I think this is another example. In fact, this was kind of the thrust of my presentation today about where language is getting us into the weeds and where we're going to lose.
Well, let's then take a look at what's going on with Brett Kavanaugh and his likely ascension to the Supreme Court. And I'm wondering how this argument about what Kavanaugh did when he was 16, 17, 18, and 19 kind of flies in the face of the doctrine that we've been talking about all morning of adolescent development.
Well, Joe, I'm glad you brought that up because when you originally approached me a couple months ago about speaking here as a keynote, I had presented a whole different presentation. And then as I watched the Kavanaugh hearings unfold, I think to myself, well, this is, looking forward to the Trump administration and juvenile justice reform, and here we have Brett Kavanaugh. This is kind of custom made for the topic, right? It is pretty much impossible to discuss juvenile justice reform today in 2018 without talking about adolescent development and the doctrine of adolescent development and adolescent brain development, because this is in many ways the most positive developments in juvenile justice reform that we've seen in the last 20 years. And I think Marcia and others spoke about it at some length this morning on the panel about how strides have been made and how there is even possibilities of further advancing the doctrine of adolescent development to perhaps move the age from 18 up to 19 or 20 or 21 even, that we're going to preempt either JLWOP, juvenile life without parole, I'll use the acronym if you'll forgive me, or juvenile executions. That whole line of cases, here's the thing about those line of cases that I think is important. They start basically in 2005 with a case named Roper v. Simmons. And this isn't a law class, but I want to talk about Simmons for a minute because I think it's important to talk about that case. A lot of people talk about Roper v. Simmons. Not very many people know the facts of Simmons. And the facts of Simmons are important in the context of what's happening right now. Chris Simmons in 19... excuse me, I forget the year it happened, in 1998, I believe, he was 17 years old, and he broke into a woman's home. He hogtied her with duct tape, a woman named Shirley Crook. He hogtied her with duct tape, and him and his friend drove her in a pickup truck to a railroad bridge over a river and then threw her in the river. I mean, it's the most horrific crime you could imagine. The facts of Roper v. Simmons are horrific. And yet, when that case went up to the Supreme Court said, juveniles have the capacity for change. They also should be viewed differently in the context of punishment because they have different abilities in their brain to process information, to make decisions, that they make bad decisions, that they underestimate risks, they overestimate rewards, and that they basically cited the science of adolescent development. They talked about a national consensus to not execute juveniles and what they called evolving standards of decency. The facts are horrific, and the reason that you say, why do you take a case like that? Well, because if you're not going to execute Chris Simmons because what he did with that when he was 17, then clearly no one is eligible for the death penalty under this standard, right? That standard has been developed and expanded to include JLWOP cases. The reason I mention it, and I'll get to this in a minute, is because clearly the courts picked the worst case scenario in terms of behavior when they thought about adolescent development and how we're going to look at it. In the whole world, you, me, all the journalists, everybody out there is watching the Kavanaugh hearings right now, and we all have an opinion. Yes, he did it. No, he didn't. She's lying. He's lying. He did it, but it shouldn't count. He did it, but it should count. What about his response? Does his response show that he's not fit to sit? We're all kind of focusing on this. And I'm horrified. First of all, I'm horrified because, not that my opinion matters, but I'm horrified because I believe her, and I think that he did these things, so that's horrifying to me. But that aside, my opinion doesn't count. What I say, you know whose opinion counts? The Supreme Court's opinion counts. The Supreme Court's opinion about adolescent development counts here. And
so does anybody want to take a different point of view than what Elton is saying? Does anybody want to disagree with that?
smart.
So we all see the contradiction, but yet, I think many of us here are appalled that this guy will be on the Supreme Court. But in light of what Elton is saying, it really adds another perspective to it, does it not?
If I may just finish what I'm worried about in terms of juvenile justice reform here, there were a dozen extraordinarily good reasons to not nominate, much less confirm, Kavanaugh to the Supreme Court. Right? Reasons that have to do with, for example, his view on executive privilege and executive power, which are basically just wrong as a matter of law, because Kavanaugh clearly doesn't understand the distinction between president and king, right? When you say that the president can't be subpoenaed, you are basically giving the legal definition of a king, a person who's above the law. And so there are real legitimate reasons. And I get it. To the victor go the spoils. I'm not saying, I'm like crying in my suit because, a conservative won and therefore they get to appoint it. That's not the point. Appoint a Supreme Court justice. That's true. He does. But you still have to appoint somebody who's qualified. But instead, what happened in this media frenzy, and I got it. It's a good story because let's face it, Kavanaugh's misunderstanding about executive power and executive privilege is not a particularly interesting story, right? First of all, it's very legal heavy. It's not something that's you can put that on CNN, and I've seen the talking heads debating it, but that doesn't play like a Me Too case coming up at the penultimate moment, right? Which is what we have now, which is a much bigger story. So rather than focusing on the real reasons, on legitimate reasons, legal reasons why Kavanaugh shouldn't be on the Supreme Court, we've now gotten into a debate about whether or not this incident 35 years ago should preclude him from the Supreme Court and/or his response to the accusations. And what I worry about is that, you know, I tell my friends, and when I argue with strangers on Facebook or whatever about this, that you know, use your head. We're writing Kavanaugh's majority opinion when he overrules these cases. Remember, Kavanaugh's replacing Kennedy. You know that Roper and Graham and Miller were all 5-4 decisions, penned by guess who? 2 of them by Kennedy. And I think of myself, because I've done some appellate work, when this case goes, and Marcia made the point earlier, these cases are going to go back up to the Supreme Court. And I think about myself standing in front of Justice Kennedy on the Supreme Court 3 years from now or 4 years from now, arguing to Justice Kennedy that, Justice Kavanaugh, I apologize, arguing to Justice Kavanaugh, his replacement, Kennedy's replacement, arguing to Justice Kavanaugh that my client, you shouldn't revisit Graham, you shouldn't revisit Miller, you shouldn't revisit Roper, that my client should be treated differently because he's a juvenile, then we don't want to hold the juvenile responsible for this entire life for something he did 35 years ago. I want to say that with a straight face to Brett Kavanaugh and see what answer you get, right? I mean, I think that when we make this argument, what we're doing is we're laying the groundwork. We're writing his majority opinion for the reversal, for the overruling of Graham, Miller, and Roper. I'm terrified. Never mind J. Elwap cases. I don't think this guy, it'll come in pieces. You know, well, maybe if you're 18 and you kill 4 cops, maybe we'll make an exception, you know, or 17 and you kill, you know, they'll make little exceptions, just like that's how they do it. That's what they're going to do with a lot of cases. So the irony being that while we collectively got kind of lost in the weeds, as I keep saying, focusing on this issue, let's make, unless more allegations come up between now and the vote, and I keep holding my fingers. But by the way, what a kind of a, I found myself all week wishing that more accusations would come up, and also thinking to myself, God, isn't that sad that I have to actually wish that somebody else was abused by Brett Kavanaugh so that they can come forward with this, right? That's so that, because I saw that as the only thing that perhaps might sink his nomination. In the absence of that, he's going to get on the Supreme Court, and he will be the new vote, right? Losing Scalia was already a minority vote, but Kennedy was the person who penned these cases, and we're going to lose him, and we're going to have Kavanaugh in his place. And I bet you he's going to be pretty pissed off about how we all tried to derail his nomination with something he did when he was 17, and I don't think that's going to play well for adolescent development cases when they come up in front of the court.
Okay, so let's go on to the final question, and then we'll open it up for questions from you guys. You had mentioned that we're not properly addressing the competency of juveniles when they're placed in the system.
Yeah, I wanted to talk a minute about competency because one of the things that I didn't hear any of the panelists talk about today is that competency is an issue that comes up often with juveniles, especially when we have younger juveniles, 10, 11, and 12-year-olds, and it's not addressed properly. Juveniles, the competency law was originally developed to address adults that are either what used to be called mentally retarded or cognitively impaired, or juvenile or adults that are suffering from severe mental illness like schizophrenia, and that frankly the adult law of competency does not translate well to juveniles. And when I talk to my lawyers in our office about competency, we have a short training video. Brian, could you show that? It's the lipstick video. If you could just show this. I don't know if we're going to be able to see it with the blinds open now. Well, let's see if we can see it. It's only about 30 seconds long.
What's on your face? What's on your face?
Lipstick.
Lipstick? Is that mommy's lipstick?
Yes.
Yes? I thought mommy asked you not to touch your lipstick.
Call Daddy.
Call Daddy? And what should I tell him?
No, not in the bed.
Okay,
No
Jill,
monkey
stop it for a
jumping in
second,
bed?
Brian. So this young defendant here has been charged with theft, receiving stolen property, and criminal mischief, right? With basically graffiti with the lipstick on her face, and there's a couple of interesting points about this.
Has she actually been, this is a joke, right?
Yeah, it's a joke. She's a little too young to be charged. But it makes an interesting point here about competency, right? Because first of all, there's a couple of it's a great point for teaching young lawyers. Because what does she do when, first of all, should the police officer who's questioning her, which is my wife, have Mirandized her first, right? Because is this custodial interrogation? Is this defendant free to leave? Well, she can barely walk, so I think she's probably not free to leave. And as we know from the JDB case, which is another adolescent development case, we're now going to look at custodial interrogation in the eyes of a juvenile. She probably should have been Mirandized, but what does she do? She invokes her right to counsel, which I just think is brilliant. She says, call daddy, right? Not once, but twice, right? Unequivocally, she invokes her right to counsel, and we know under the law that when a juvenile or an adult invokes their right to counsel, that all questioning that must stop, and that anything that follows after that must be suppressed. So in this case, I tell the lawyers, you clearly have to file a motion to suppress. And in fact, you see that the police officer here continues the questioning, even though she's invoked her, and is asking questions that are designed to elicit an incriminating response. Don't you know that you're not supposed to touch the makeup or the lipstick? And she continues to ask the questions. But what was the answer to the one question, what should I tell daddy? And she says, basically, it's almost incoherent. She says, monkeys in the bed, which is a reference to that song about monkeys jumping in the bed, which made me think really very, very soon about competency, right? Is she even competent? She's really not competent. She's only, certainly to be a defendant. But in the context of 8 and 9 and 10 and 12 and 10 and 11, 12-year-olds, you will get answers that are not so different from this. A lot of 10 and 11 and 12-year-olds who've been arrested by police do not really understand what's going on, are not able to participate in their own defense, don't understand how to respond or deal with or interact with police in ways that protect their rights. So the system, what happens if a juvenile is declared incompetent is that in our jurisdiction and in many jurisdictions, the juveniles just languish. Because the adult law of competency states that we basically wait to see if if competency can be restored. But in the context of juveniles, that doesn't make a lot of sense. Juveniles often never were competent and never will be competent, especially if we're dealing with cognitive impairment. So this is an issue that has to be addressed and focused on. I saw Mary Ann Scally nod her head when I mentioned competency because it is a problem. And we have kids right now in the system, 10, 11, 12, 13-year-olds, who just sit. It's not, if a court declares you're incompetent, it's not as if they just say, okay, charges are dropped, go home, see you later. You stay in the system. You may be put into the dependency system, but you're basically institutionalized, and the prosecutors will wait 6, 12, 18, 24, 36 months to see if competency can be attained or restored. And I'm not going to talk right now because there's neither time and there's also a panel about this, but we see what the Trump administration is doing with separating juveniles from adults just as basically as a negotiating tool to discourage people from crossing the border. And much to my chagrin, it's actually apparently having some success. So they can not only do it, but they can claim, see, it works. Of course it works. So it doesn't make it any less brutal or horrific, right? That the Trump administration is not particularly sympathetic to or kind about the plight of children in the juvenile justice system.
Yeah, we're going to have a panel tomorrow about what's going on at the border.
She did because she called. Daddy was called. So.
She got a presidential part.
Yeah, I told her to. What I told my wife was, first of all, I told Felicity to stop talking immediately, not to say anything. And then I told my wife that, because my wife showed me the video, and I told my wife that I had already filed a motion to suppress her inculpatory statements, and that it would certainly be granted under laws in every state in the nation. That she had every duty to stop questioning after the defendant implicated her Fifth Amendment right to counsel.
All right. So, anybody have a question? Yes. Go ahead, please.
Can you repeat that?
1 second, please.
Kelly, say your...
Kelly Davis. I'm a freelance reporter from San Diego, and actually the story I'm working on for this project is on juvenile restoration to competency.
Oh, great.
And I think 4 states do have competency laws or a system in place. Is anyone doing it right, or is there a program that can be used as a model for? other places?
Well, when you say have some sort of system or competency laws in place, every state has laws about competency.
Or I guess that have a separate
A juvenile
system.
specific competency.
Yeah.
We don't have that in Pennsylvania, and I'm not familiar with the research on that. I do know that in Pennsylvania we're doing it wrong. That what's happening in my jurisdiction is that juveniles are basically deemed incompetent, and then they just languish in the system. They sit there, and the cases get 3-month, 6-month reviews. We come back, and then there's arguments about whether or not the child is now competent. Either way, the child is basically in a bad position. If the child is not competent, the child remains in the placement that they're in. If they are competent, now the Commonwealth will now seek to prosecute them. I don't see, in my mind, as a criminal defense lawyer, what should happen if a child is incompetent is that here's the thing about competency evaluations. A properly done competency evaluation is supposed to make a determination about whether, in that expert's opinion, in that forensic expert's opinion, competency can be attained or restored. I much prefer the word attained rather than restored, because restored suggests that at some point in the past your client was competent, and often with my clients that's not the case. So I will object to the word restored. Again, going back to this issue about the use of language, right? If you concede a discussion about whether or not competency can be restored, what you're basically conceding implicitly is that your client was competent before, and I'm not willing to give them that. So I will object to any evaluation that talks about restoration of competency or about prosecutors talking about restoring competency. In my case, it's about attainment of competency.
Okay, so we're running out of time. I want to ask you 2 questions. What's the biggest fallacy about the criminal justice system really getting better? Is there a fallacy, or is that really the truth? Well, what is the thing that's not getting better?
You know, many things are getting better because there's a lot of very motivated people who care a whole lot. Some of us are sitting in this room right now working very hard to make things better, and inroads have been made. The work that Bob Listenby has done and the work that NJDC has done and the work that JLC has done bears real fruit across the country. It's also true that when you go into the courtrooms and you see what's going on, a lot of it is still the same old song. So the frustration for me, the fallacy is, for example, in the context of waiver hearings, and this was talked about a lot earlier in the day, and I was going to talk about waiver, transfer, certification. It goes under different names. There's a whole body of law about it, and there's different ways to do it, and I teach it in my juvenile justice class at Drexel, and it's all very interesting. But what happens when you go into the courtrooms in Pennsylvania is, outside of Philadelphia, that in most of the counties what's going on is that the lawyers are just waiving the issue. They're not even litigating it. They're just letting their clients be tried as adult without even litigating the issue. So all the work that Mary Ann Scally or the JLC or that Bob Listenby at OJJDP or that I've done through JDAP, doesn't matter. If the lawyers are just going to stand up there and waive the issue and say, try him as an adult because that's how it's done in that courtroom and that's how it's done in that county and that's how they do it, or because if they make an issue about it, they're going to fall in disfavor with the judge or whatever, it's either fear or because it's the practice, then all of this research and work doesn't mean a hill of beans, right? And that's the problem. And I've talked to Mary Ann Scally about this on many times, the frustration about going out nationally and trying to educate people and train people, and then when you get out into the courtrooms, what you see what's happening makes you want to cry.
Okay, anybody else that has any questions? All right, we'll take this as the last question.
Well, I don't know if you could answer this one too quickly, and sorry if you've answered this many times already. I'm from Philadelphia, where I grew up in the Lynn Abraham era. She was kind of a famously pretty strict prosecutor. So I'm wondering, how has the Larry Krasner era lived up to your hopes? Where has it not lived up to your hopes?
Maybe that's a little bit inside baseball you can discuss.
Well, I think it's actually a nationally
I can answer that quickly.
Yeah.
First of all, you may be interested in knowing that I was so impressed with the work that Larry Krasner is doing along with Bob Listenby, who's his first assistant chief, that I took a job with them and was about to become a DA. I was supposed to start on July 27th and work with Larry and Bob as a district attorney in Philadelphia. And after mulling it over for a month, I just couldn't do it, and I called them up and said, I'm a PD at heart. I can't be a DA. You're doing great things. I love what you're doing, but I can't be part of that. So I admire what they're doing, and I think that their efforts are bearing a lot of fruit and have made real significant changes in how people are being prosecuted in Philadelphia. Having said that, I often say in my office, I told Keir the other day, I'm glad you're all feeling the love, but I got to tell you, in juvenile, we're not feeling the love yet. So that it hasn't actually trickled down so much on the juvenile side. I had a meeting yesterday, I had lunch with Bob Listenby yesterday and talked to him about these concerns, and he told me that they're in the process of making changes in their juvenile unit, and for me to be patient. So I believe that there are going to be changes in how they approach the juvenile justice end of it also in Philadelphia. That was not their priority. I think they started with homicide and were working their way through other areas. But so far, we haven't felt the love in juvenile, but I think we're going to soon.
So this Philadelphia then would be a really good a place for reporters from around the country to take a look at, see what they're trying to do, see the problems that they're encountering and what they're actually accomplishing.
Absolutely. I mean, I think that, especially if you are inclined, and I hope you all are, to give Larry Krasner positive publicity, because he gets a fair amount of negative publicity, please come to Philadelphia and sing his praise, because he's doing amazing things down there. He's not the only one. There's some other, I think there's a prosecutor, I believe, in Dallas is doing some similar work in other places. But there has been some really, what's happening in Philadelphia is so monumental, so newsworthy and so innovative that I was ready to leave a career of 25 years as a public defender just because I wanted to be part of it. I mean, it's really that monumental. So, yeah, come to Philadelphia and talk about it.
He was our keynote speaker a
Thank
month
you
ago.
very
here.
much.
I heard that, and I think that's fantastic. So,
Round of applause.
thank you very much.
We're going to move right to the next panel. No rest for the weary.